You have a document in a drawer that you believe protects your family, a power of attorney. You paid a lawyer for it. You signed it in front of a witness. And when it comes to your Social Security check, it does almost nothing. The Treasury Department does not recognize a power of attorney for the purpose of handling federal benefit payments. Not Social Security. Not the needs-based payment. That is not my opinion. It is written on the agency's own website, in plain letters, where almost nobody goes looking. So if the day ever comes when you cannot manage your own affairs, the person you chose, the one you sat down with a lawyer to name, walks into that office holding a document the agency is not permitted to act on. I want to say the next part slowly because it is the reason this video exists. There is a separate form for that. There is a separate form for almost everything in this system, and not one of them is going to arrive in your mailbox because the entire program is built to answer what you submit and nothing else. Today, I am going to give you 5 of them. 5 forms in the order they will actually matter to you. 2 of them decide who is allowed to speak for you, and one of those 2 you can only file while you are still perfectly capable, which is exactly why nobody files it. One of them is the difference between paying $202.90 a month for the rest of your life and paying a permanent penalty on top of that forever. And the window to use it is 8 months wide, and it does not reopen. One of them is worth roughly $5,700 a year to the average person who qualifies, and it takes about 10 minutes to fill in. And the last one is a form that lets you undo a decision you already made about your own Social Security, which almost nobody knows is possible, and it is the one with the hardest clock on it, so stay with me for that one. My name is Kevin. I read the rules, so you do not have to. Every week, I go looking for the thing that quietly decides what happens to your money, and I bring it here before it costs you anything. If that sounds useful, subscribe and turn on the bell, because the 5th form on this list closes 12 months after you file for benefits, and after that, it is gone permanently. Form number 1, the one that fixes the drawer problem. It is called SSA 1696, the Appointment of Representative, and it is the form that actually does what most people believe their power of attorney already does. Let me explain the gap first, because until you see it clearly, the rest of this will not land. A power of attorney is a state law instrument. You create it, you name somebody, and banks and hospitals and title companies generally honor it. That is real, and it works. Social Security is federal, and it runs on its own rules. The agency's position, which it states openly, is that a power of attorney does not make a finding about whether you are capable, and does not by itself grant anybody the right to handle your payments. And the Treasury regulations that govern how federal payments are made do not recognize it for that purpose at all. So what happens in practice is this. Your daughter telephones the agency to sort out a problem with your check. She has the document, she reads them the relevant paragraph, and the person on the other end, who is not being difficult and is following the rules they are given, tells her they cannot discuss your record with her. That is the moment families discover this, and it is always the worst possible moment to discover it. The 1696 closes that gap. It is you, while you are fully capable, formally naming somebody to act for you in your dealings with that agency. They can then receive information about your record, they can be present, they can help with an application or an appeal, and they can receive copies of the notices the agency sends. Now here is what it does not do, and I want to be exact rather than encouraging, because this is where people misunderstand. The 1696 does not hand your money to anybody. It does not take a single decision away from you. You remain entirely in charge of your own affairs. The person you name is standing beside you, not in front of you. And you can name almost anybody. It does not have to be a lawyer. It can be your son, your sister, a friend from church. If they are a lawyer or a professional representative, there are rules about fees, and any fee has to be approved by the agency, which is a genuine protection. But a family member helping a family member does not charge a fee, and that is what most of these are. 2 practical points before I move on. The form is free. You can get it from the agency's website or by telephoning and asking them to post one to you, and both of you sign it. You sign to appoint, and the person you name signs to accept. Send it in and keep a copy, and if you hand it in at an office, ask them to stamp your copy in front of you. And name somebody younger than you. I say that plainly because a great many people in this audience name a spouse of the same age, which is entirely natural, and also means that on the day it is needed, the person named may be in exactly the same position you are. Name your spouse if you want to. Name a second person after them. Now let me tell you about Berdine. Berdine is 83. She had a stroke, recovered most of the way, and now has good days and days where the words do not come out in the order she wants them to. Her son Ray handled everything after it happened. The bank was fine, the hospital was fine, the insurance company was fine. He had the power of attorney, and every one of them accepted it. Then a letter came from Social Security about her payment, and Ray telephoned, and for the first time in 8 months of managing his mother's entire life, somebody told him they could not talk to him. He thought he was being stonewalled. He was not. He was holding the wrong piece of paper, and there had never been a moment in his life when anybody told him a right piece of paper existed. Berdine could still sign. She was capable, on a good day, in the morning, sitting at her own table. So they filed the form. It cost nothing, and it took an afternoon. But there was a version of that story where the stroke was worse, and there was no good morning, and the form was no longer available to her at all. That is what the quiet rules is for. The plain list of what you need in place before anything happens, printed large enough to read without hunting for your glasses, with the form names and what each one actually does, so that nobody in your family is standing in a hallway with a document in their hand being told it does not count. It is at kevinexplains.shop. The link is in the description below and in the pinned comment at the top. And if you are watching this on a television right now, there is a code on the screen you can point your phone camera at. 7-day guarantee, always. If it does not hand you something you did not have before, you send it back. Form number 2. And this is the one I said you can only file while you are perfectly well. If the agency ever decides you cannot manage your own benefits, it appoints somebody called a representative payee. That is a person or an organization that receives your money and manages it on your behalf. They pay your rent, your food, your medical costs, and they keep records and answer to the agency for how it was spent. That determination is made by them based on medical evidence, and it is not something your family votes on. The form somebody files to be appointed is SSA 11. Now here is what almost nobody knows, and it is the reason this is on the list. You do not have to wait for that day and let the agency choose. There is a process called advance designation. While you are entirely capable, you can name up to 3 people in the order you want them considered to serve as your payee if you ever need one. 3 names, in your order, chosen by you on a day when nothing is wrong. And you can do it in a few minutes through your online account or by telephoning them or in person. You can change it whenever you want. Naming somebody does not start anything, does not give them a penny, and does not suggest to anybody that you are declining. It sits in the file and does nothing until the day it is needed. Think about what the alternative looks like. If there is no designation on file and that day arrives, the agency works through its own order of preference to decide who is suitable. In a family that agrees about everything, that may land where you would have wanted. In a family that does not agree, and most families do not agree entirely, it lands wherever it lands. 15 minutes on an ordinary Tuesday while you are perfectly fine. That is the whole cost of it. And let me be honest about what a payee actually is, because people picture something worse than the reality, and it stops them planning for it. A payee is not a guardian. They do not gain control of your house, your other bank accounts, your medical decisions, or anything else you own. Their authority covers your Social Security payment and nothing beyond it. They are required to spend it on your food, your housing, your medical care, and your personal needs, to save what is left over for you, and to keep records and account to the agency when asked. So it is narrower than most people imagine, and it is also supervised, which cuts both ways. It is a protection against somebody misusing your money. It is also paperwork somebody in your family will be doing on your behalf, and that is worth knowing before you name a person who would resent it. Which is the actual argument for doing this in advance rather than letting it happen. If you name the people yourself, you can also tell them you have done it and why and in what order. That conversation, had once at a kitchen table while everybody is well, prevents an entire category of family argument that otherwise happens in a hospital corridor. Form number 3. And this is the one that costs the most money when it is missed, because the penalty never ends. If you turned 65 and did not sign up for Medicare Part B because you were still working and covered by your employer's health plan, you did the right thing. That is allowed, provided the employer has 20 or more employees and the coverage is through current work, yours or your spouse's. But when that coverage ends, a window opens, and it is 8 months wide. 8 months from the day the employment ends or the coverage ends, whichever comes first. Inside that window, you enroll with no penalty. Outside it, you are pushed into the general enrollment period, which runs the 1st of January through the 31st of March, and you pick up a penalty that follows you permanently. Here is the penalty. 10% added to your Part B premium for every full 12-month period you could have enrolled and did not. Not once. Every month for as long as you have Part B, which for most people means for the rest of their life. The standard Part B premium this year is $202.90. A 2-year delay adds 20%, which is roughly $243.50 a month instead. 3 years is 30%, and that surcharge appears on every premium statement you ever receive after that. The forms are CMS 40B, which is your application for Part B, and CMSL 564, which is the request for employment information. You fill in the first one, your employer fills in part of the second one, certifying the dates you were employed and the dates the coverage was in place. That second form is what proves you qualify, and it is the piece that waives the penalty. Now here are the two traps, and they catch people who are being careful rather than careless. The first is that COBRA does not count. Neither does retiree coverage. I want to be blunt about this because it is the single most expensive misunderstanding in Medicare. If you retire and take COBRA for 18 months and feel entirely covered the whole time, your 8-month window started when you stopped working, not when the COBRA ran out. People find this out at month 19, and by then the penalty has already attached. The second is the employer. That L564 has to be signed by somebody in the Human Resources Department, and Human Resources Departments are slow. And if you retired from a company that has since been sold or closed, tracking down a signature can take weeks you do not have. So do not start this at month 7. Start it the week the coverage ends. And there are 2 more things inside this that catch people, so let me name them both. The first is the size of the employer. The exception only holds if the employer has 20 or more employees. Below 20, Medicare becomes the primary payer at 65, whether you signed up or not, which means the employer plan is only paying second, and you may have been going without the coverage you were actually relying on. If you work for a small business, or your spouse does, that is a question to ask the Human Resources Department in writing this week, and the question is simply whether the plan is primary or secondary for employees over 65. The second is the gap. If you do miss the window and land in the general enrollment period, you do not simply pay the penalty and carry on. Your coverage starts the month after you sign up. So somebody who realizes in April has to wait until the following January to apply, and then waits again for it to begin, and spends that entire stretch without Part B at an age when that is exactly when you need it. And if you are watching this and a penalty has already been applied to you, do not stop listening because there is one more thing. There is a process called Equitable relief. If you did not enroll on time, or you enrolled in the wrong thing because you were given wrong information by somebody acting on behalf of the federal government, you can ask for the penalty to be removed and for your enrollment to be corrected. It is not automatic and it is not a guarantee. It requires you to describe what you were told, by whom, and when, and it works far better when you have something in writing, which is the practical reason to write down the date, the name, and what was said every single time you speak to anybody at that agency. A note in a diary is not proof of much. It is a great deal more than most people have. Let me tell you about Rodell. Rodell is 70. He worked at a printing company until he was 67, and when he left, they offered him 18 months of continued coverage, and he took it. It was the same card, the same doctors, the same everything. He had health insurance every single day for 18 months. He never went a day uncovered. In his mind, that is what mattered. His window closed 10 months before the coverage did. He is now paying a penalty on his Part B premium every month, and he will be paying it in 20 years, and he will be paying it for the rest of his life, because the 8-month clock was measured from a date nobody drew his attention to, and the card in his wallet said he was fine. Nobody lied to him. Nobody at the printing company knew the rule either. That is exactly the gap this guide closes. Not to make anybody an expert in Medicare enrollment, to make sure that the one date that starts a clock is a date you know about while you are still standing inside the window, instead of a date somebody explains to you afterward when nothing can be done. Same place, kevinexplains.shop, link in the description and in the pinned comment at the top, and the code on your screen if you are watching this on the television. 7-day guarantee, no argument. A man opening a premium statement, seeing a number that is wrong by a fifth, and knowing it will be wrong every month until he dies. Form number 4, and this is the one worth the most money to the most people watching. It is called Extra Help, officially the Low Income Subsidy, and the form is SSA 1020. Here is what it does. It pays your Part D prescription drug premium. It removes the deductible entirely, and it caps what you pay at the pharmacy counter at about $5.10 for a generic and $12.65 for a brand name drug. And once your out-of-pocket drug spending reaches the annual cap, which is $2,100 this year, covered drugs cost you nothing for the rest of the year. The agency's own estimate of what that is worth to the average person who qualifies is roughly $5,700 a year. Now the limits, because this is where people count themselves out before they ever apply. For this year, the income limit is about $23,475 a year for one person, or about $31,725 for a married couple. The resource limit is around $18,090 single and $36,100 for a couple. And listen closely to what does not count as a resource. Your home does not count. Your vehicle does not count. Your household goods do not count. Burial plots and a burial fund do not count. Life insurance does not count. So the house you own outright, the car in the driveway, and the plot you already paid for at the cemetery, none of that is part of the calculation. An enormous number of people rule themselves out on exactly those things. 3 more pieces and then I will move on. The first is that the old partial subsidy is gone. It used to be that some people qualified for a reduced version. Now everyone who qualifies receives the full subsidy. The second is that this is separate from the state program that pays your Part B premium. Different program, different office. But they connect, and it works in your favor. If you qualify for one of the state Medicare savings programs, you are automatically enrolled in Extra Help as well. So if you are applying for one, ask about the other in the same conversation. The third is the application itself. It takes about 10 minutes. You can do it online, by telephone, or in person. You do not need to send bank statements with the initial application. There is no cost, and there is no penalty of any kind for applying and being told no. That last part matters more than any figure I have given you. The worst outcome of applying is a letter saying you do not qualify. That is it. Nobody is ever worse off for having asked. And 2 more things worth knowing before you do. Some people are enrolled automatically and never have to apply at all. If you have full Medicaid, or you receive the needs-based payment, or you are already in one of the state Medicare savings programs, you should be enrolled without lifting a finger, and you should receive a letter confirming it before the start of each year. If you are in one of those categories and no letter has ever arrived, that is worth a telephone call, because being automatically eligible and being automatically enrolled are not always the same thing in practice. And if you are enrolled, check the drug plan you were put in. When somebody is auto-enrolled, the plan is chosen for them, and the plan chosen may not be the one that covers the specific medications they actually take. You are free to switch to a different plan, and if you have extra help, you can generally change plans without waiting for the autumn window. So being enrolled is the first step, and being in the right plan is a second step that a great many people never take. Form number 5, the one with the hardest clock in this video, SSA 521, the request for withdrawal of application. This form lets you undo the decision to start your Social Security, not adjust it, cancel it. The agency treats the application as though it was never filed at all, and you are free to apply again later at an older age, which means at a permanently higher amount. That matters because for every year you wait past your full retirement age, up to 70, your benefit increases by roughly 8%, and it stays increased for life, and it carries into your survivor's payment after you are gone. So if you claimed early and something changed, and you now think you moved too soon, this is the door out of that decision. Now the conditions, and every one of them matters. You have 12 months from when your entitlement began. 12. After that, the door closes and it does not reopen. You have to repay everything. Every payment you received, every payment a spouse or child received on your record, every dollar that was withheld for Medicare premiums or for taxes, all of it. Anyone else drawing on your record has to consent in writing, and you get this once in your entire life. There is no second withdrawal, ever. It is also a 2-part process, and this is where people get frustrated. You send the form in and it goes to a processing center rather than being handled at your local office. Then they calculate what you owe and send you the bill. Nothing is finished until that bill is paid. Given how those centers are staffed, that takes considerably longer than it should, so if this is something you are considering, do not begin the paperwork in month 11. Let me tell you about Nolia. Nolia filed at 63. She had been laid off, she was tired, and the money looked like a rope in the water, so she took it. 4 months later, her sister asked her to help run a small business, part-time, steady, and suddenly she did not need that payment at all. She had 8 months left, and she did not know the door existed. She found out about it 2 years later from a neighbor in a grocery store car park, and she is going to receive a reduced payment for the rest of her life because of a decision she made in a frightened month and had every legal right to reverse for 8 more months without knowing it. That is the entire problem with this system in one woman. Not a rule that treated her badly, a rule that would have helped her enormously and had no route by which to reach her. Now let me give you my honest opinion, which is only that, and you are welcome to disagree with me in the comments. Look at what these 5 forms have in common, because it is not obvious until you line them up. Every one of them has to be filed before it is needed. The representative appointment only works while you can still sign. The advance designation only works while you are still capable. The Medicare window only exists for 8 months. The withdrawal only exists for 12. And extra help pays from the month you apply and not 1 month earlier. This system does not reach backward for you. It barely reaches backward at all. And that is a design choice, not an accident. A program serving tens of millions of people cannot make individual judgments about who intended what. It has to run on filings and dates, because filings and dates are the only things it can verify at scale. I understand that. My objection is narrower. If a program is going to be built entirely around the rule that you must ask before the moment arrives, then the obligation to tell people what to ask for and when has to sit somewhere. And right now, it sits nowhere. It used to sit with a person across a desk who would look at your situation and say, "Have you thought about this?" That conversation has largely disappeared, and nothing replaced it, and nobody announced that it was gone. So it fell to you. That is unfair, and it is also simply the situation, and the only useful response is to do the asking yourself. All right, here is your list. 5 things, and every one is a form or a phone call. 1. If you have a power of attorney and you believe it covers Social Security, it does not. File the appointment of representative form and name somebody while you can still sign it. 2. Set up an advance designation, naming up to 3 people who would manage your payment if you ever could not. 15 minutes, changeable anytime, and it costs nothing. 3. If you or your spouse are still working past 65 on employer coverage, mark the day that coverage ends. The 8-month window starts there, not when COBRA ends. Get the employer form signed early, before the company or the person who signs it disappears. 4. Apply for extra help, even if you are certain you will not qualify. Your house, your car, and your burial fund are not counted, and being told no costs you nothing at all. 5. If you filed for Social Security within the last 12 months and have had second thoughts, telephone and ask specifically whether the withdrawal form is still available on your record and what your exact deadline is. And if your own situation is tangled, if you are not sure which of these applies to you or which date your clock started on, write to me. The address is on your screen and in the description below, and I read every one that comes in. One last thing before you go. Berdine's son had the right intentions, the right document, and the wrong piece of paper. And he only learned that in a moment when it was nearly too late to fix. Rodell was covered by insurance every single day for 18 months and will pay a penalty for the rest of his life anyway, because a clock started on a date nobody pointed at. And Nolia had 8 more months to change her mind about the biggest financial decision of her life, and she spent all 8 of them not knowing. Not one of them was careless. Not one of them was refused anything by a person who wished them ill. Every one of them needed a single sentence from somebody at the right moment, and there was no one whose job it was to say it. So say it to yourself this week, while nothing is wrong. Find out what you have signed. Find out what date your clock started, and file the thing before you need it, because in this system, that is the only version that works. I am Kevin. Thanks for watching. Do not forget to check the quiet rules at kevinexplains.shop.